Okay, so we have a very special class today. Jennifer Kelly has flown up from San Francisco to be with us, and I will let her tell her story because it's a good one and a powerful one if you want to practice in this area. I see it as my job to do a few things and get the heck out of the way so that Jennifer can have as much time as possible. So I'm going to try and be done by 11:10, and if I can be done earlier than 11:10, I will be. So update number one, the first edition of Video Game Law is up on the wiki, on the website, in the open, thanks to LexisNexis, and thanks to the Center for Teaching, Learning, and Technology at UBC. If you go to the website, you will see a new tab called Textbook UBC Wiki. Cut and paste to your heart's content. The one thing that is not yet working, and I have to sort through, there's a couple of little pieces. So Creative Commons license isn't up, but that won't affect you as students. It should be up any time now. But what will affect you is the search function within the book isn't up. But the book's not that long. The chapters are all there. The footnotes are all there. And it's clickable. So hopefully we'll get the full search function up very quickly. It's not without its complexities to implement. And I'm not sure UBC Wiki has fully implemented that. But the book itself is totally there. So hopefully that will help you in your research and perhaps even help students elsewhere with theirs. Because I get a lot of requests, especially from Europe, for the book because it's very, very hard to get. And it's not the second edition, and it's certainly not the third edition, but I still think it's massively cool of LexisNexis to allow this to happen. Project Oculus, I'm meeting with Maria today to figure out the room situation, and with Dan Silverman to figure out the bandwidth situation and how this is all going to work. It won't be next week, but it might be the week after or the week after that. So we're still very much trying to do it. Now we're into the logistics stage, and we'll figure out how to do signups. The open badges thing seems to be working. I am going to ask for an update as to who's, not who identity-wise, but how many people have reached what levels, and we'll put it up here. Not putting up a leaderboard or anything like that, but just so you guys know. And unless there's any feedback, I'm hearing nothing about it, and it seems to be working. There'll be an FAQ coming, and I have not seen the redesigned custom video game law badges yet, but I expect they're coming this week, and I have a meeting on that on Friday. Okay, so if you didn't think this course could get any weirder, it's going to get a little bit more weird, and then I'll try and bring it to some level of sanity, and I can assure you Jennifer will bring us to full sanity.
That's no fun.
your normal function in life. So noticed something after the class last week, and I would say it will make you think I'm weird, but you already think I'm weird. So you'll remember this slide. Nick Bostrom of Oxford. Are we living in a computer simulation? Fairly decent chance that we are living in a computer simulation of some future inhabitants of the Earth. And then you'll remember from a totally different part of the presentation, this slide. Is this a video game? The process of creating a model of the world using multiple feedback loops and various parameters in order to accomplish a goal. Sounds like a video game, but in fact, it's Michio Kaku's definition of consciousness. Now, if you put that together, you go to a really weird place. And that is that, isn't it strange that Kaku's definition of consciousness aligns so well with video games? And could that be because Bostrom's right? So that was my incredibly weird thought for the week. It's, you know, I mean, I'll talk about this a little more. And then, you know, these are slides you've seen that tend to be confirmatory of how the map of our consciousness and the map of video games are connected. Well, sorry. And I'm still freaked out by it. Has anybody watched Reading Minds? Does it amaze you as much as it amazes me?
Yeah, it was actually really interesting just being able to see, you know, what people are looking at, for example. I remember that was the early part of the video.
I mean, it's well worth watching it because you can understand it scientifically. This is not, you know, woo-woo weird stuff. This is, if we take continual pictures of your brain as it's looking at things, and we know what you are looking at, then we can, just by looking at your brain, know what you're looking at. It's very simple, it's very scientific, and it obviously has a lot to do with where the future of privacy is going. But it also shows how the map of our brain and the map of our consciousness and the map of our world is very interconnected and very aligned. All of which leads to this question, which I think anyone who plays games a lot will, or even a little, will understand. Why are we so obsessed with pursuing confusion between what's virtual and what's real? Because we do that a lot. Simulations, we are fascinated by it. And this ties into, you know, briefly we talked last week, and I really stand by movies being kind of a wonderful projection of our subconscious obsession with this, because we're so obsessed with the inside the game stuff. And all of this also kind of supports the notion of this kind of strange alignment between, are we living inside a video game, and the map of our consciousness is in fact a video game, or works like a video game. And, you know, a kind of more mundane example of what, you know, what happens if you use ingress and drones and control them through an Oculus Rift. You're basically living in a whole different world. And I just wanted to show you this slide because it's from the Kleiner-Perkins stuff that you saw last week. Slide 142. This is, you know, the real deal. Oculus Rift enabled drones. One of their big predictions for the future. And I saw yesterday that a drone almost hit an airplane somewhere. Anyways, we're going to hear a lot more. And if you want to get really, really out there, if anybody's followed this controversy in physics, the math is suggesting that it's possible that we in this world are in fact in a hologram. and we're just a two-dimensional projection of another cosmos. If that other cosmos is our video game player master and we are the Sims, even that makes some sort of strange sense. All right, so now we will come back to Earth. This Earth in this time, and assuming that we have free will and this is all real and we're not living inside a simulation. And there's a pretty good chance that we aren't, and that these are all correlations. But just because they're correlations doesn't mean they don't mean something, and that they don't mean something about how we as humans are built and our relationship to games, and that there aren't real and logical implications of that for the law. So let's go to the conventional for a minute. And you might remember this quote from the first class. And I didn't have an answer, and this is from my relative Leon Festinger in the book The Human Legacy. This is a lifelong psychologist who came up with the theory of cognitive dissonance. Equally strange is our general addiction to games, including electronic games. This is 82. We even assemble in huge crowds to watch others playing games. What does all this mean? I can find nothing in the literature of scientific psychology that helps me to understand such bizarre behavior. Why do we play games? Well, if how we are conscious and gaming are profoundly aligned, we have an answer to that question. It's actually wired into us in some way. So we can take Michio Kaku without his observation, without Nick Bostrom and Are We Living in the Sims, and get to a logical place in this world where we have real laws. And that's really, in some sense, what we're going to talk about for the rest of at least my part of today. And that notion that how we are conscious and video gaming and gaming generally is profoundly aligned, we've already seen lots of support of. Jung saying, Jung being Jung, it's all about the instinctive self, and the instinctive self makes really good games. I mean, he actually says that. It's kind of an extraordinary thing. But it goes to that deeper place, very well aligned with Kaku. My colleague Kimberly Voll, Play is Evolution. You've seen that as well. That suggests profound alignment. McLuhan, I mean, I was invited to do this last week, so I'm doing this for all of you, sort of tracking it all through. We've talked about all this stuff. Games as social reaction. And one I haven't mentioned for a while, but you've seen it before, and this is Przybylski hypothesizing that we're motivated to play video games to the extent they allow us to sample our ideal self characteristics. Again, we're aligning our consciousness with gaming. And this helps answer kind of one of the things that you might recall I was struggling with, and I think it's a sub-theme of what we were all struggling with. Who are we in game? So again, none of these slides are new. So this is Lee Alexander's piece about watching her significant other create a gaming character in another sex, and sort of questioning all sorts of identity-related issues. And then this piece from The Guardian, also about the identity paradox in games. and then our assignment of playing the Stanley Parable, which certainly goes to the question of our identity. Which leads us to Boyden, where we pour meaning, where we pour our identity, creating consciousness into the shell of the game. So that's looking at Boyden as not an IP academic, but as a philosopher, as has been suggested in the class. And it works. So let's just pause on Boyden for a second. So we got two things, and we just need to separate them and hold them for a second. We have this question of consciousness, the alignment of our consciousness with video games, which at its extreme can be interpreted as being consistent with us being in a game, or it can just be consistent with why we love games so much. It just aligns with how our brain works. And if you go there, the latter place, the more sane place, then you have this other issue of identity and immersion, which becomes very natural around questions of consciousness. But where do these identity immersion, how are they birthed? They are birthed through connection. If you were alone in a room your whole life and never came into contact with anything else, it's unlikely that you would have identity issues. You'd have all sorts of issues, but you might not know what an identity issue is. And that takes us to video games as post-structuralism. So one more proof that when you're looking, if you want to make sense of all of this, if you look at games as post-structuralist mechanics, then all of it, consciousness, differing versions of identity, all makes sense. And everyone, the confusion between who is the creator and who is the gamer gets writ large. And this notion of Bostrom's that we're in a game, you can just read as a metaphor. Because if we are in the game, don't you feel like we are all players and we all have some form of free will? And therefore we should have rights. Anyways, it's definitely, if you go back, I don't think it gets better than Boyden. Systems are shells into which users pour meaning, therefore users have rights. And the Supreme Court of Canada has said so, so we can easily make it that simple. If games are post-structural, the list that I'm going to get to later in the course of analyzing these things and saying, how do we look at these different issues, and is the law aligned with them if games and consciousness really are what they appear to be? And post-structuralism as a mode of analysis works. So, legal question, is it too much to ask that law aligns itself with what we've already said is aligned? And copyright law does not seem to align very well as currently structured. It forces an owner, it forces concepts of a creator, it does all sorts of things on a relatively exclusive way that if this notion of how our consciousness is built and how our games reflect that, copyright's just not a good fit. Now, what's really weird is that contract law, which I've been really pretty nasty about for a couple of weeks, if it's done in a truly one-to-one unique way, aligns quite well with post-structuralism. Aligns completely naturally with it. Not mass contracts, not not click-throughs, but actual contract law. No two contracts being the same is a very, very healthy post-structuralist concept. It's just that it's right now misaligned in how it manifests in games. Right.
Do you have any proposal for how it could align with games?
Yeah, the best I can do, and I will try and do better when I get to the ethics lecture, which is the last one, because obviously I'm setting myself up here with problems that I'm going to at least try and have some suggestions on. The best I can do is something that I've harped on a bit, which is, what if the fact that deep data is being used by Facebook and Google and can obviously be used by others to individually address us with information, why can't that be mapped onto our contractual relationships? Why can't every person, the technology surely would allow me, Expedia, right? Is that where you make bookings for hotel rooms? And so I think Expedia would allow me to say where I want to go, for how many days, with how many people, what my price range is, et cetera, et cetera, et cetera. A technological solution that allows me to define what I would agree to in an end-user license agreement, and then identifies those end-user license agreements as they're coming in that don't align with my needs, would start a change where, if I say, gee, this isn't important enough for me to agree to this, you might see companies going, okay, we're going to start addressing you individually. If they can address us individually in terms of what ads they can send us, don't tell me they can't address us individually on the terms of the contract. They can, they don't want to. And they're not even going the other way and coming up with a standard form for the industry. So yes, that's a criticism. So that may take you to the place, the mapping, the overall mapping of Michio Kaku of games and consciousness as one thing, which is my interpretation. He might be aghast by my saying that. Takes you to, or takes me to the place of answering what was previously a question in the slides, and suggesting that creativity and connection is in fact more important than property to our consciousness, and not can I mod, but I can mod, or should be able to mod. So that was all the unconventional stuff. Now let's go to the purely conventional, but though still hopefully very interesting, analysis of controlling creativity in the video game idiom. So the largest manifestation of, or the most significant manifestation of how we control creativity is really embodied in concepts of originality and what we do and how we mediate questions of originality in video games. And that's really, starting now, what Jennifer and I are going to talk about for the rest of the class. So, again, just to place you, we finished creating, we finished connecting, and we're now on controlling. And if you want to think about controlling and what is controlling in at least modern Western democracies, for the most part, it's creating chills. This is a media law journalism term, chilling out the media. Where somebody doesn't do something that perhaps they could because they're concerned that the law may intervene. So in journalism, if you're afraid of a defamation suit, you might not report a news story, or you might report it differently, or you might hold back in some way. So controlling this whole section of the course, this last section of the course, or aside from kind of the summary part, is really about figuring out where the chills are. And they may be warranted. They're not automatically bad because they're there. But they need to be identified and brought into consciousness. Now, this is really subject matter of next semester's course. But I just want you to see a map of how we control, how we chill, from start to finish. This is a map. If you are a creator and you're down here, you will feel control elements that change what you do at every level. And they will start with community. Right now, because of Gamergate, I have colleagues who are afraid, are having a hard time creating, teaching, doing things. That's a community issue. I put it as extra legal. There also can be legal manifestations, but they show up there. Many of you know when you're trying to even write a term paper, you're very reliant on your technology. It lets you do some things, and it doesn't let you do other things. And sometimes you want to pound it because it's not letting you do the thing you want to do when you want to do it. Then we get to copyright. Then we get to other intellectual property stuff. Then we get the EULAs and contracts. Then we get to privacy, defamation, personality law. Huge swaths that we've covered in this course. And those just directly affect whatever you're creating. And they're private. And they don't necessarily, they're private law. They might, obviously, they may have some statutory background to them, but they're essentially mediated person to person. Then you move beyond the creation, you kind of go to others. And industry self-regulation, even though you can argue it's private, it has kind of a quasi-governmental tinge to it. And Then we get to consumer protection, taxation. These are all issues in games. Just use video games. Obscenity laws and other criminal laws, internet governance and surveillance. All of those, in one way or another, can impact any creative work, certainly any video game. This is sort of a map of the things that can come up, but it's also a map of the constraints. It's a map of the control mechanisms. And the first 6 layers have to do with what's original in the game. And the top 5 limit behaviors outside the game, for the most part. So I want to now go back to last week where we were, using sort of the most far-fetched example of brain gaming and, truly immersive virtual reality. And most of the issues are going to be privacy with a little bit of consumer protection, thanks to Ryan Caleb. But here's the real issue. And somebody picked it out last week, and I apologize for not remembering exactly who. But it's this issue of what happens to the magic circle in all of this. And remember, the magic circle is the fence that keeps real-world laws out. Now here's the problem, stated as simply as I can state it. If our brain is mapped on, mapped with, mapped through, fully aligned with the structure of games, then this is a futile exercise. Because consciousness encompasses all that we do, whether we're in the game or outside of the game. And we'll talk about it next week, because that's when we're talking about social issues. But if you think about Gamergate, maybe that's a way of thinking about it. And realizing, no, when you try and put these fences and say this is separate, we live in a separate world, and the ordinary rules of misogyny don't apply. Maybe it just doesn't make sense to do that, and this is why. Because we actually are fully aligned. We are conscious gaming beings. And the magic circle, though very interesting, though very clever, may not be real. So to examine that possibility, and the magic circle has always been the way we fended off, saying, you know what, real world laws should only come into game spaces so far. And I really invite you to think about whether the underlying issue in Gamergate and the reason that it's triggered so much emotion is holding on to that basic principle. We want our games, we want our separate space, we want our full freedom within that space, and the ordinary rules don't apply. And is that not the underlying dialectic? So, again, we'll talk way more about it next week. But where does the magic circle come from? Johan Huizinga, obviously pre-gaming, identified this notion of temporary worlds within the ordinary world dedicated to the performance of an act apart. Sports, games, courtrooms, et cetera, et cetera. And then, we're not going to do wall of text, and I'm going to let you read this on your own. But what I've done here is consciously gone through papers that started in 2003 and moved roughly till about 2010, at which point people stopped talking about the magic circle for a reason I'll show you. These are academic papers, and what you will find is that the early papers from people who are awesome, like Greg Listowka and Jack Balkin, are all trying to carve out some notion of the magic circle and saying law should not come into gaming, at least within certain parameters. And Balkin was the first to say, look, the more games look like the real world, the more real world laws have to come into it. But since games don't really look like the real world, as long as they don't, as long as they're not using real world monetization, we're okay. There should be some separate part of this. And then you start moving into phase 2, which basically says we're going to have to deal with. And at this point, it was clear that real-world monetization was coming in, and you couldn't keep the law out of the sacred space completely. And so this kind of middle group of papers were saying, yeah, we have to set up very careful regimes, legal regimes. There will be law, there will be regulation, even within game, but we have to do it thoughtfully. And there was very little, and I think this is the interesting part, there was very little that said, here's how you can do it. And I think that's a hint for where we're probably going here. But I think the best one, Joshua Fairfield, who's awesome, players in virtual worlds should understand that their behavior online is not entirely free from real-world scrutiny. This is a bit saddening. It was wonderful to live in the cyber Wild West, but every new frontier has its civilizing moments. So this is fairly typical of that middle generation of academic work.
Makes sense to use in-game arbitration, because that's what corporations do. They have their own sets of rules and their kind of there's some world
Yes.
operate in that's separate from the normal world, and usually corporations go to arbitration with their employees and things like that to deal with them.
And in fact, I don't know if the footnote made it into the second edition, but I have this giant footnote that you'll find now online in the first edition saying, why have we not created international arbitration? And I wasn't thinking so much as in-game, but I was thinking a lot about the disputes that Jennifer litigates. Why? Because how gaming companies and how deal with each other, and developers deal with distributors, and gamers deal with developers and distributors, is its own world, and it's not its own world in terms of not being subject to law. It's its own world in that, well, Jennifer and I were talking about this morning, when you bring in a litigator who doesn't know anything about games, it's actually a disadvantage to litigate that case. I'll let you talk about that more. But what we're talking about here is not that issue of whether law applies, but how should it apply through arbitration mechanisms, or, as I've suggested, technological mechanisms that allow my identity to be known to the people I deal with, et cetera, that facilitate all that. This is still in the place of, should we have a magic circle or not? And the magic circle is shrinking, and this is sad, but necessary. And how far will it shrink at this point is the question. And then we get to Mia Consalvo, who is professor at Concordia. Well worth looking her up because she's sort of the Canada Council professor. You know, she is in a world of increasingly serious video game academics. She is, I think, in many ways the most serious, and she is a Canadian, and she is one of ours. So we should take some pride. And again, I'll invite you, in light of Gamergate, to read what she wrote in 2009. There is no innocent gaming. Players also have real lives with real commitments, expectations, hopes, and desires. This is also brought into the game world. She's looking at World of Warcraft as her sort of academic playground, if you will. We can neither ignore such realities nor retreat to structuralist definitions. I love that. Of what makes or defines a game. Games are created through acts of gameplay, Boyden, which is contingent on acts by players. There is no magic circle. That's her argument. And others have pretty well gotten there. And there's been almost no work on reinstating the magic circle since Mia Consalvo did her work. No one's tried and said, there is a magic circle. And I think in some of the things that we're seeing going on now, her words are looking pretty prescient. I also obviously seize on them because she's clearly a post-structuralist. And I certainly didn't know that when I first found that quote a couple of years ago. So now, if the magic circle is shrinking or has shrunk, now we're back to, that means law pervades. And if law pervades, we're back to the question of originality and IP in video games. And I may suggest to you that because the magic circle is no longer there, we have to therefore change the law. Because the law rules. And the law is not aligned with how we really game and with our consciousness, et cetera, et cetera, et cetera. That may be my argument. That argument puts absolutely no money in Jennifer Kelly's law firm's pocket. So it may or may not be a good argument, but the law rules. And so we're back, I think, where we should be, to Boyden as, if we're going to analyze what the law, how the law rules, step one is, if it's a system, then it's not copyright intellectual property. And then there are other things which Jennifer is going to take you through, of things that don't qualify for intellectual property protection. And what you're left with is what may be protectable. And I'm not doing this analysis because we have a special guest who's the best in the field to do it for us. Bunch of cases and articles just so that you have them if you're doing your paper in this area. And then just yesterday's news, which bears on this personality case, but Manuel Noriega's case against Activision has been thrown out of court. And you'll see that. Also, if you are interested in a sort of 20-minute version of my take on the subject of originalism, with Jennifer's permission, I took her slides previously, melded them with my own, and did a presentation at Full Indie, which you'll find on the website. It really is it's 22 minutes. I whipped through it. It's going to be many of the same things you've heard, but kind of from my perspective and in my way. And next week we are, what a timely class. So next week, this was always the class about violence. And then we would talk about sexism in that context kind of towards the end. And, next week ends up really being about misogyny as violence, because that's where we are right now. And without further ado, other than to get myself unhinged and hinge up Jennifer, we will.
Well, while John is getting my slide deck as it's up, I wanted to say that I am very excited to be here. This is the third time that I have lectured in John's class, and I can never say no because it's my favorite thing to speak about. And John is a friend of mine, and I'll do anything for him. And the one thing that I would like for him to do is to teach this course in the spring so that I can work in a boondoggle ski trip in Whistler like I did the first time that I taught in this course. But for some reason, here we are, it's the fall, and I'm working when I'm not in this classroom. Now, before I get started, I just sort of want to get a sense from the people in the room. How many of you would consider yourself gamers? How many of you are thinking that you might want to be a litigator? Okay. A little bit of overlap there. Not a coincidence. All right, so I am a, where do I do the thing right here?
Towards you. Here, no, sorry. It's this side thing.
Okay.
And you pull it towards you.
Okay.
There you go.
Okay. All of this is so much fancier than when I was in law school. We didn't have microphones. We didn't have video. We didn't have slide decks. Professors didn't use slide decks. This is a totally different world. So before I get started talking about the substantive matters that I'm going to talk with you about, I thought it would be helpful for me to talk a little bit about who I am, what I do, and how it is that I came to be litigating cases in this area, which for me is a dream job. I graduated from UCLA Law in '97, so I've been in practice for 17 years. And it was only about 6 years ago that I really started to get into this area. I happen to be a gamer myself. I have been my entire life, starting with the Atari Pong, and then the Atari 2600 I grew up with. And in my home, I currently have a Wii, PS2, PS3, an Xbox. I also do happen to have an Atari 2600 that I bought on eBay and about 40 cartridges, but I don't really get that one out because it takes up too much space. And this is my second Xbox because I burned out my first one. With the
You had the Red Ring of Death.
I got the Red Ring of Death. If you guys know what that is, it means you played it a little bit too much. You'd think that the platforms are for my children, but they're not. They're really for me. And they do enjoy them, but I play games way more than they do. So I've always had a passion for video games, and it was about 6 years ago that I had my first case in this area. It was the Capcom versus MKR case, which I'm going to talk about. It involved a movie and a video game in the zombie genre. And we litigated that case, and we won. And I was super fired up about it. And I thought everything about that case was fascinating and fun, and I really wanted to do more in that area. I had already been practicing in the soft IP space, copyright and trademark and right of publicity and what have you, but I hadn't done anything specifically in the video game area until that case. And after that, there started to be more disputes in the area. There was the Psycho Monkey versus Zynga case. I don't know if you all know that case. It's when Zynga came out with Mafia Wars, which looked a lot like Mob Wars, and so there was litigation over that. And I was very interested in that, and I decided to build a practice around this because there wasn't really anybody that was doing it and owning it. And so I sort of wrote a business plan, and I presented it to the powers that be at my firm, and I said, this is what I want to do. I really want to develop an expertise in this area because when you're a partner at a law firm, you do a lot better if you have a specific practice, not just to be a generalist, but to have a specific practice. And so I decided that I wanted to do this. And I presented a proposal, and on my proposal happened to be speaking at a conference where John was in attendance. And I spoke about the cases that I'm going to talk with you about today, and we got to talking afterwards, and it sort of just took off from there. And I've been advising companies on staying on the right side of copyright and other IP content in the development process. And I help them out if they get a demand letter. Fortunately, none of my clients have ever been sued, and I'd like to keep it that way. I have sued. I brought declaratory relief actions on behalf of clients that have been threatened with litigation where we concluded you don't have a case, and we're going to go ask the court to declare that so that there's no cloud over our rights. So we've done that, and one of those is the Capcom case. And more recently, I have been on the plaintiff's side. I'm going to talk about the King versus Six Waves case, where we have actually filed a lawsuit and gone after the companies that clone. And this is big business. As you all know, there is a ton of money in the video game world. These games generate enormous revenue, especially with this freemium model where you download the game for free and then you have these in-app purchases. Candy Crush being a good example of that. I mean, people that get addicted to these games, they just, well, my client wouldn't like me to use the word addicted. It would like me to use the word highly engaged in these games. And, people spend a lot of money to help progress throughout the game. And so there's a lot of money in this. And so there's a lot of companies out there that rather than invest the resources to develop games that truly are their own, they free ride and clone. And so there's been a lot of litigation over that, of which I've been involved. Okay, so the kinds of IP claims that commonly arise in games, I've listed here: copyright, trademark, trade dress, right of publicity, and patent. Now, there hasn't been very much patent litigation, but I'm starting to see now amongst my client base companies thinking more and more about using patent protection to cover aspects of their game that are not covered by copyright. And so I think that we may be starting to see a little bit more of that going forward. Patents take a long time to get, shorter now with some of the new rules in the patent office, but it takes a while. So it's not something that out of the gate you're going to have a weapon in your arsenal unless it's it's technology that you've already patented and you're using it in a bunch of games going forward. As John mentioned earlier, the right of publicity, there was this case that came out yesterday. I actually haven't had a chance to read the opinion yet, but I think it's definitely something that is worth reading. The state of the law on right of publicity has gotten a bit scary to the point where I often advise my clients, if they've done something that somebody may claim infringes on the right of publicity, please don't do that. That's too risky because you don't know what a court is going to do. And it's very hard to, the First Amendment comes into play in the right of publicity cases, but not in the same way as it does in trademark. Have you guys had somebody come in and speak about right of publicity in this course? I know you had somebody on trademark.
Yeah.
And was the First Amendment defense covered?
Yeah, it was, right of publicity was covered to some extent in there. I may do a bit of a tutorial on it next week at the beginning of the class because I think looking at Noriega, there's a good, I want to talk about Noriega and EA and a few of those cases. So I'll pull those slides from the presentation that I sent you and just do a focused right of publicity. So you don't have to worry about it other than to say it's important. It's also very different in Canada than the United States. I think it's much tougher and much scarier in the United States. Here, right of publicity has always come out of privacy law and is quite well circumscribed by provincial statutes. And it's a little out of control in the United States from what I've seen.
Yes, it is a little bit out of control. And so this opinion might be worth reading because I'm told by one of my colleagues who read it and emailed me this morning that there was some reining in of that So maybe there will be a little bit of a change here. But this kind of thing comes up a lot. I have a lot of clients that want to put, a famous building in a video game. And I said, that's fine. You're going to be fine. Or somebody's trademark, probably going to be fine. But somebody's image or likeness, no. I actually had a client recently that I took a look at a character in their game, and I said, look, I know your developers think that you've parodied this person sufficiently, but they're going to recognize themselves. And they're probably going to raise a stink about it. Can you just, give the guy a mustache and, change his name, and can you do these things? And it's like, okay, easy, done. But, they have to be told this because they don't really understand how much trouble that they can get into if they don't do it. So that incidentally is, of course, one of the fun parts of my practice, being able to tell a company, put a mustache on the guy. Cure that little problem.
Have any of your clients ever tried to put you in the game? Like, that would be so much fun.
That would be fun.
Yeah.
That would be fun.
But lawyers, nobody thinks of lawyers that way. They don't think of us.
No, we're not. They don't think of us as fun.
Who really would love to be in the game.
Yeah. Okay, so I'm going to talk about how, toward the end of the presentation, hopefully I'll have time to get there, I'm going to talk to you about how I go about analyzing copyright claims. And that focuses on things like examining the genre and knowing what is part and parcel of a genre. For example, in the zombie genre, what would you expect to see in any game based on that genre? In the first-person shooter genre, what do you expect to see in that genre? What are the things that we need to weed out and say this can't be protected by copyright, and what are you left with? And I'm probably going to spend the most time on the recent cases.
Towards you.
Toward me, okay. I think I went one too far. Okay. All right, so because I am in the U.S., I live and practice in San Francisco, I am going to focus on these cases are all from the U.S.
There has been, to my knowledge, no Canadian case in this area. So I think you're in good ground.
What about DJ cases up here? Have there been any Canadian companies that have filed a DJ action up here?
I'm sorry, define DJ.
Declaratory judgment. We don't infringe
No.
your copyright.
No.
Okay.
No.
But that is an available remedy.
It is an
in
available
Canada.
remedy.
Okay.
There's no question. It's just we don't, for reasons that have to do with the international nature of video games, the most of the litigation is in the States, and then there's pockets in Europe.
Okay. Now,
We're not a large market. At the end of the day, we're a large producer. We're a disproportionately large producer of video games,
yes.
but we're not a large market
Yes.
in which it plays
Yes.
out.
I heard recently that there are a lot of developers that are located in Toronto because there are certain tax benefits to being there.
That's true. That was really true 3-4 years ago, because the talents in Vancouver, the indie indies are becoming way more important than they used to be, right? And the indie developer scene is almost entirely here.
Interesting. So just to give you a little bit of background, I think you guys are all second and third year, so you probably had civil procedure already and hopefully know what a declaratory judgment action is. But just in case you don't, it's a tool that is used frequently in the intellectual property space when somebody is threatened with a lawsuit. They get a demand letter, and there's an actual controversy between the parties. The party who has received the demand or the threat can affirmatively go out and file a lawsuit asking the court to declare that there's no infringement. And this can be an important tool because when you've got this threat hanging over you, and sometimes the video game company's distributors might be brought into the threat, or Apple, for example, might get a letter. And what do we do about this? How do we clear our title to this game? And so that's something that you see very frequently in the copyright and the patent context, including in the game context. So under U.S. copyright law, what copyright protects is the expression of ideas, not the ideas themselves. And so what good lawyers need to do is to make arguments that the things that you are claiming are protected are expressions of that idea. And by the same token, if you're a defense lawyer, what you want to do is you want to argue, no, no, no. What you're claiming that I copied is an idea. It is a high-level idea that nobody can own under copyright. So the way that this is played out in the case law is that in games, things that are protected are the overall look and feel of the game's layout, the game sequencing and progression. And what I mean by that is sort of the course of events that can happen. And I've argued in various contexts that this would include progressing through certain levels. If you have a game that has 117 levels, what happens at level 1? What happens at level 2? What happens at level 3? Are things progressing in the same order? Are boosters being introduced in the same order? First you get the cherry, then you get the banana, then you get the grape. And compare and try and see if there's a similarity between the games in that regard. And I analogize it to video games are literary works, and what's protected in a literary work? Storyline. And so in much the same way that a book progresses through a story in chapters, video games progress. When you play them, different things happen along the way. And so I always look for what happens in terms of the game sequencing. There can be protection for instructions and text. The protection there is thin. You have to have nearly verbatim copying word for word. But oftentimes what happens when instructions are copied is that there's also similarity in the visual presentation. We see this a lot in tutorials where the two games will have a character pop up, and there will be a box, and the box will be the same color, and the words will be very similar. And so you argue that the instructions have been copied, but you're also arguing that it's the visual presentation that's been copied. The storyline, I say not plot because plot is generally considered to be an idea. It's too high level. You have to really get down into the weeds and have more detail around the story to be protected. Developed characters, and I say developed because stock characters are not protected. If you have somebody who's a karate champ, that's too abstract. But if you have somebody that's got a name and a certain look and a certain personality, that can be protected.
Can I ask just one question, because I've never seen any litigation on it, but I wonder. Sometimes you see ads for games, and the game might not be that similar, but sometimes the ads are virtually clones of each other.
Yes.
Have you seen that? Do you have any experience with that? Have you just wondered about that?
I have not seen litigation over it. I have advised clients on that in terms of, I had a client whose ad agency came up with a campaign for a game, and they weren't even a game company. But these days, everybody's got an app. And it was a company that had an app that incorporated their product, and it looked very similar to a very popular game that you would all know if I said it, but I can't. And I looked at this and I said, oh God, no. No. And even if the actual game, the app that you're building doesn't actually look like this ad, you're going to get sued or you're going to get a letter. And you please just go tell your ad agency to start from scratch, and this is not okay. But yeah, absolutely.
Because, I'm half expecting to see, I'll use a mundane example, but, in a number of years ago where EverQuest, there was a certain motif to do with EverQuest, and you started seeing that in other game ads and in other ads generally. It was kind of the fantasy art genre, and again, idea, expression, problems. But I'm half expecting to see a lot of ads that are sort of Minecrafty in time.
Yes.
There may not be objections to, let's say, a mod of Minecraft, but there might be an objection to an ad that uses a Minecraft motif.
Yes.
Very different.
Yes, absolutely. And then, of course, we have protection for the code itself, but people aren't copying the code. That's not what's happening. People are looking at the game, they're playing the game, and they're building a game that's like it. They're not actually directly copying the code. Sounds, of course, are protected. Music is protected. That I'm not seeing. I'm not seeing people copying sounds in music. What copyright law does not protect is general concepts, themes, and genres. things that fall within the doctrine of saint faire, which have you talked about?
No,
saint faire?
this is your deal.
Okay, saint faire, it's a French term. It means the scene that must be done. This is something that it flows from the genre. Like I mentioned, if you have a first-person shooter game, what are you going to have? You are looking at the game from the perspective of the shooter, and you've got a scope, right? I mean, those are things that you're going to see in every first-person shooter game. So those things are not protectable under copyright law.
And you have a great zombie story.
Yes, yes.
So don't worry if you don't get that.
Yes.
And I have mentioned said this affair, in an early lecture, but you're the person to contextualize it.
Yes, yeah.
Because I know how well you do that one.
And to the point that I made earlier, good lawyers know how to make arguments about which side of the line. Is this an expression or is this an idea? The saint faire doctrine is really a place where if you know the genre very well, or if you're just creative, you can put something in a box or take it out of the box, depending on how persuasive you can be. But when thinking about this doctrine, it's very important to always hone in on what is the particular genre, what is the subgenre, and be very familiar with it so you understand what are the things that I might be able to argue are or are not protected under copyright law. What does not protect? Method of play. Little vague as to what that means, and we're going to talk about game mechanics in a second because I understand that there was a request that I address that. Stock characters, real life elements, things like sports moves or bodily functions, and we're going to talk about that because there was a case on that point. Didn't result in an opinion, but there was lots of people like John and me who speculated as to whether that case would have had any teeth because it was based on things that people do in real life, and therefore wasn't exactly fanciful. And under U.S. copyright law, historically, games that fall more on the fanciful spectrum, like Pac-Man, get more protection than games that fall in the real-life spectrum, like a golf game or a karate game, where you can pick apart pretty much everything in the game. Well, of course, you have to have a scoring system. Of course, you have a hole-in-one. Of course, you have a certain karate move. That's karate. That's not copyright. That's not creative. Let's see, other elements driven by the genre. That's sort of another way of saying saint faire. Functional aspects of the game. We're gonna see that in an argument that somebody attempted to make when they were sued by Tetris. Things that are functional or driven by function are not protected in copyright law. That's something that you need to get via patent law if you can. And finally, content that's not original to the author. This is a very common defense in these cases. What the defendant has argued in some of the cases we're going to talk about is, well, yeah, I copied it, but you don't own it. You copied that from somebody else, so you can't sue me for it. It's a common defense, and it is an effective one. And that is because the elements of a claim for copyright infringement are ownership of a registered work and copying of protectable elements. People tend to get really caught up in the second element and focus on it and think about similarities between the works. And sometimes they don't pay enough attention to the first element, which is what do you own? What did you create that is original? And that is the place, as a defendant, I go to town. I dig. When did you register the work? What does the registration cover? What are the elements that you're claiming that I copied, and which of those might have been from a work that you copied from somebody else? Or somebody's already done it, you just don't own it. The defenses that come up are independent creation. Oh, I didn't copy you, I came up with this on my own. Usually it's pretty obvious whether they did or they didn't. The not original point, and finally that the works are not substantially similar. Yes?
So why is it need to be registered?
Well, under U.S. law, you have to have a registration, or at least you have to have an application to register on file before you can sue.
Not in Canada. So in Canada, we have copyright as of creation. Mm-hmm. And you can register, but it has no legal probative value except sort of marginally on a who's first
And
basis.
it's not a prerequisite to filing a lawsuit.
Not at all.
Okay. So do companies register their copyrights?
No.
No? Okay. It's a pain. It's a pain, and a lot of companies don't do it, even in the U.S. And it's a more complicated process than you might think. And but it's really important to register it in a timely manner. And I always advise the companies register their works within 3 months of the date of first publication, because if you do that, then it's as though it was registered. The date goes back to the date of publication. And why does this matter? For one thing, in the U.S., you have to have a registration on file. It has to be applied for. It doesn't have to be issued before you can file a lawsuit. And the other is that it gives you certain remedies that you can't get. Statutory damages is one of them. That doesn't matter in these cases. In video game litigation, the big ticket is actual damages. It's the infringer's profits and actual damages suffered by the copyright owner. Statutory damages come into play, and they're more important in other cases, like a Napster, for example, where you had hundreds and hundreds and hundreds of thousands of works at issue. The statutory damages could quickly add up. In a video game case, you've got 1, maybe 2 works at issue, and statutory damages are per work, not per infringement. So the most that you could conceivably get is $150,000 per work. That's pocket change in this world. But the thing that's more important is that having a registration at the time the infringement commences entitles the copyright owner to attorney's fees. And that is meaningful, because litigation is very expensive. And so for companies to have to face liability, not only have to turn over all of their profits and any damage that the copyright owner suffered that is not duplicative of the profits, to have to pay their attorney's fees, that can be pretty scary, and it can drive people to want to settle things very early before those attorney's fees.
So if you can imagine that the attorney's fees obviously must be outstripping the $300,000 limitation.
Oh, yes. It doesn't take very long to hit that. Litigation is incredibly expensive, in addition to being disruptive and all these things. I mean, I am a litigator, but I am very, very clear with my clients who are thinking about litigation as a plaintiff or potentially facing exposure for something that they're doing. I always tell them, you do not want to do this. You do not want to go into this lightly. It's going to be expensive. It's going to take up the time of your people. There's things, I guarantee that there's things that you've done that you don't want the other side to know about, and they're going to find them. I mean, I'll try to do the best I can, but sometimes that stuff comes out. Yeah, litigation, I think, it's not, to say that if you were to litigate one of these cases through trial, it could easily be $3 million plus. So early settlements, which usually happen, will avoid that. That's one reason to settle early. So these are the cases that I'm going to talk about with some nice side-by-side screenshots. Has anybody read any of these cases that are on this list? Okay. Have you guys spent time talking about any of them?
This is your moment.
Okay. All right. Oops. Okay, I'm going to start with the Atari versus North American case. This is a pretty old case. It was one of the first that really addressed, the where the line is in video games as far as what is an idea and what is expression. And as with all video game litigation, this case has an interesting backstory. Litigation is never as simple as it may seem. So this Atari had the license to make a home version of Pac-Man. And I believe it was licensed from Namco.
Yeah.
And it was in the process of developing this. I mean, we all remember, right? Well, actually, I'm sorry, I'm way older than you guys. But I certainly remember playing Pac-Man in the arcade and the tabletop version. And boy, was I excited when I heard that there was going to be a version for the Atari 2600. And so Atari was working on this, and North American beat them to the punch. And they built this game on the right called Casey Munchkin. I'm sorry, the game on the left. Casey Munchkin. They built that for the platform called the Odyssey. And Atari was furious and sued them in, I think it was the Northern District of Illinois. And they sought a preliminary injunction, which was denied. They appealed that to the Seventh Circuit, and they won. And what the court said was, look, there's no protection for the general concept of having a maze with ghosts and goblins and munchers and having these wraparound tunnels where you pop out one end and you come in the other, using dots to gauge a player's performance. There's no protection for that. Those are ideas. But the way that they are expressed, that can be protectable. And what the court found in this case was the distinctive gobbling action of the Pac-Man character, the way that it went like this, that was protectable. And the way that when the ghost got it, it collapsed back onto itself in a starburst pattern, that was protectable. And the unique way, the unique interaction between the characters, when you ate the big pellet, then you chased the ghosts. All of those things were protectable under copyright law. So North American, they got...
Are those gameplay mechanics?
Well, oh yeah, I think I skipped that slide. So sorry about that. You know, let's talk about game mechanics for a second.
See how artfully I did that?
Yes. I'm not good with this thing. Where is that slide? I know it's in there. There we go. Okay. What are game mechanics? I mean, I created this little slide, you know, are they protected? Answer, yes, no. Depends on how you define the term. We don't know. What do you guys think the answer is? Did I hear something?
I was going to say all of the above.
Yeah, I thought about that too. Yeah, I think that's the right answer, actually. We don't really know. You know, what are game mechanics? If you argue that game mechanics are things like actions and sequencing, then absolutely. But if you argue that game mechanics are things that are functional, then absolutely not.
So the distinction being the munching Pac-Man collapsing onto itself. What is that?
Right.
As a piece of art, it may be protectable. As a pure piece of code, it's not.
Right.
So you're living in this two-dimensional world, which of course always gives litigators something to argue about.
Yes.
Because you can, your opposite number, whatever you're arguing, your opposite number will say the other thing.
Yes. 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 And that's what you see when these cases get filed. There's always a lot written about them. When you read the articles, you know, people form opinions. There's certainly lots of comments that always get posted, and people have pretty extreme views sometimes. But you'll get people who see a particular thing very different ways. The court in the Atari case described this as movement. It actually used the word movement in the opinion. You don't see game mechanics. But when I see complaints that I have not drafted that use that refer to copying of the game mechanics, I think, oh, they're in trouble. They're exposing themselves to. They're just teeing that up for the other side to just smack it down. I also don't usually use the term. I don't refer to similarity of gameplay. Mm-hmm. I may talk about the games being virtually identical, because that is often what happens. It's basically the same game with slight variations.
But when you do that, you're talking about the artwork, the geometry, the sounds,
yes.
the look and feel. Sorry, I know
yes.
I'm taking a little bit
yes.
of your thunder, but
but yes, and the game progression, because
yes.
that is how gameplay. That's what people really should be saying when they're referring to the gameplay. And I'm going to talk about that when we get to the Spry Fox case, where the court used the term object hierarchy. But what it was really talking about was game progression, how you progress through the game and what happens along the way.
I think that's all you need to do. But I mean, that is really important that you guys understand that game mechanics is kind of an overwrought concept. Mm-hmm. And really, there's nothing there that's different than the stuff you've already heard about copyright and the creative aspects of it.
Yes.
There's no hidden magic that's a game mechanic that's protectable. And anybody who suggests otherwise, I think, is slightly on the hysterical side. And you would agree with that.
I would.
It's just that's people glomming on to things because they want more IP protection than really exists.
Yep. Yep. When my clients start talking about that, I say that you got some patent applications on file? Because
Yeah,
maybe you
chill
should be
it.
going down that road. Okay. All right. So this is the Capcom case that I mentioned earlier. We filed it in February 2008, and we got the opinion in, I want to say, October 2008. The opinion came out the day I made partner, so it was a pretty exciting day for me. And the judge had been sitting on the opinion for a month, and his clerks forgot to post it, so it was actually dated earlier than it was much earlier than it was written, or that it was posted. So what happened in this case, we represented Capcom, which came out with this game called Dead Rising for the Xbox 360. Do you guys know this game? Anybody? Okay. It's a fun game. And I'm a big fan of the zombie genre. I like all things apocalypse. I like all things bloody and gory. So this was a dream case for me. Dawn of the Dead was a 1979 horror film directed by George Romero, who did, I think, 5, and there may be more now, 5 movies in this series, the first of which is Night of the Living Dead. And Dawn of the Dead was the second one in the series. And this movie was set in a suburban 2-level shopping mall. And what happened was there was a massive zombie outbreak. You had 4 survivors that were trapped in the mall. They were barricading it, and they were trying to survive and battling zombies along the way. And the main character in the movie was I think he was a journalist. He was a reporter. And then the main character, this guy here, Frank, he's a photojournalist. And what happened here was the company that owned the rights in Dawn of the Dead for the U.S. threatened to sue Capcom. And the threats and negotiations had been going on for quite some time, and it just couldn't get done. And I happened to be representing Capcom in connection with another dispute. And I kept looking at this and saying, we can take them. Come on, we can win this one. Hire me. Let me do this. And so they finally said okay. And so I got the okay on a Friday. I spent the weekend learning all about the genre. Now, who can tell me what genre this is?
Shopping mall survival zombie outbreak.
Not bad.
Yeah. Well, it's called the survival horror genre. It is, I found this entry on Wikipedia, and I started reading about it. Yes, it's on there, and it's basically it's a genre that involves Tomb Raider is in it, and there's a bunch of games that are in it. And what it involves is there's some kind of apocalypse, and survivors are holding up in some structure, looking for the tools that they need to survive: food, water, shelter, weapons. And so I started looking at this and saying, gee, everything that they have identified as being the same is part and parcel of a genre. Well, you can't have a copyright on that. So I drafted the complaint, and we filed it like that Monday or Tuesday, and we were off to the races.
And remember, the complaint here is to say the other side is out to lunch by claiming a copyright infringement.
Yes.
We want to just push this aside so that the game is out from under any cloud.
Yes. And another important reason why DJ, people use the declaratory judgment tool is when you're going to have a battle over forum. MKR was in New York, and Capcom's U.S. office was in California. And I felt more comfortable with Ninth Circuit law than I did with Second Circuit law for this, and so I wanted the client to be in the Ninth Circuit. And so we filed a declaratory judgment action in the Northern District of California. And, they made a big stink and said, you knew we were going to sue you, and we're going to sue you in New York. And then they actually did sue us in New York, and I wrote them a letter, and I said, good luck. I'm going to get that case stayed or transferred. Now, do you want to have the fight out here? Because that's where we're going to have it. And they said, okay. So they dismissed that, and they counterclaimed in the California case. And what they argued in their counterclaim was that these were the similarities. The main character that I had mentioned, the fact that it was a suburban mall with 2 levels, fact that they used items to kill zombies. They pointed to a quote. There's a quote from the movie that's where a character says, when there is no more room in hell, the dead will walk the earth. And in our game, one of the characters says, "This is hell." Now, does that sound similar to you? Nice try. Zombies wear plaid, okay? That the National Guard quarantines the town. I mean, come on, right? When you have a zombie outbreak, obviously you have a quarantine. And that is why, okay, this is the Santa Fe thing, the little nugget that John promised. That is why you have helicopters in the zombie genre. Because when there's a quarantine, you cannot drive out. You have to fly. And most people don't know how to operate jets. So helicopter is the rational choice. And there was a use of a helicopter to escape them all in both works. And we argued, helicopter, Santa Fe, not protectable. And the court agreed. The other thing that they...
Yeah, let's pause there.
Okay.
Come on. Take that in. The court agreed that helicopter evacuation is a necessary part of any zombie horror genre work.
Yes.
Is that an accurate legal description?
Yes. Yes. I mean, this is why I said, it's so important to understand the genre and to make arguments about whether something is truly just a creative, unexpected thing that you might have, or it is something that is just part of the genre.
This is why this is the greatest area of law in existence.
It's fun. Well, the best part about this case was we moved to dismiss their counterclaim. And it's pretty hard to get a copyright claim tossed on the pleadings. Assume you guys learned that in civil procedure, the difference between summary judgment and a motion to dismiss. So what we did was we gave the court's clerk an Xbox. And we submitted the games in connection with our motion, along with a request for judicial notice that the court take judicial notice that this is a well-defined genre. And we had, I think, 27 games attached. We knew it was inappropriate, okay? We knew the court wasn't actually going to look at these other things, but you can't unring the bell, can you? No. So the court was at least subconsciously confronted with the fact that, wait a minute, this is not novel. None of this stuff is novel. It's been done to death. And yes, I use that expression in my motion. It's been done to death. And when we won the case, the press release said it's game over. So the court actually did play the game, and we had a very entertaining hour or two long oral argument, and came out with the opinion, which I encourage you guys to read. It's quite entertaining. Yes?
You mentioned that they argued that there's some similarities between the lines from Dawn of the Dead and what the character says in Dead Rising.
Yes.
I was thinking about Duke Nukem 3D, I guess. It's called. Duke Nukem, he took lines from Army of Darkness, and those were verbatim lines. And I'm wondering, did 3D Realms ever get sued for that? Or was there an issue with that? Or was it considered parody because Duke Nukem was sort of a funny name? Is that, like, what was going on there? I don't know if you're familiar with.
There would have been in my view, there would have been a discussion about parody. Because Duke Nukem itself, that character and that game is ironic and parody filled. So my guess is that there may have been a discussion because the words are the same. But the one way I could see counsel saying, look, do you really want to do this? Because this is an awful lot of money to spend. And there's going to be a defense. So it's not like we're going to just be in and out of court and we're going to succeed, because we're going to have a fight about parody in video games. And there hasn't been a lot of that. And so we're going to be the first case.
Yeah. I didn't put fair use as one of the defenses on my slide. I used to have it on my slide, and I took it off simply because that's just, it doesn't come up very often. In that situation, I could absolutely see that there being, because parody is a piece of it's one of the factors of the fair use analysis. But it's just, it's not what I'm seeing in terms of when games are cloned or copied. And it has to be enough that it's really worth it for the company to want to sue. And in that situation, I wouldn't think that it would be enough there, that it would be financially.
And the other thing just to bear in mind is all the cases that Jennifer is going to refer to, all of them are about commercial interests versus other commercial interests.
Yes.
We're not talking about mods here. We're talking about that first layer of commercial ripping off of other commercial interests, or not.
Yes. Yes. Oh, remember I mentioned there's always a backstory. The interesting backstory here is Capcom had approached MKR about a license before it came out with the game, and the talks didn't go anywhere. And when they came out with the game, they had they put a disclaimer on it. You can't see the disclaimer, but there was a prominent disclaimer that said this game is not in any way affiliated with George Romero's Dawn of the Dead. And another thing, it wasn't a great fact, but one of the developers came to the sort of the premiere of the game wearing a Dawn of the Dead T-shirt. You know, it's like, come on, do you have to be so in your face about it? So those are the kinds of things that can generate emotion on the other side. Sometimes people don't file lawsuits for rational reasons. Sometimes they file them for emotional reasons. So, yes?
So is the fact that they tried to license it, can that be taken as evidence that it did copy it?
It is fodder for attorney argument. It is not going to change the ultimate analysis of whether it is original, whether it's substantially similar or not, but it is going to give the other side room to make other arguments, such as, well, you had access to the work, you clearly knew about it because you asked us for a license, or you clearly thought that you needed one, but at the end of the day, no. And that happens in a lot of these cases. There's talk about a license. And I think this actually happens more in the context of when developers want to use trademarks or they want to use somebody's likeness. There's more awareness there that a license is needed. And I actually have a client that knows that it needs a license to something. They're building a game. They know they need a license. And they are afraid to ask for one because they think if the price is too high, they don't want there to be a record that they had made the inquiry.
Also, let me tell you the case that I'm waiting for that I think is inevitable. And that is a developer working with a major gaming company to jointly develop a product that doesn't go ahead, but the underlying IP belongs to the major company. The developer wants to build the game that has not been green-lighted and then has to change the game enough to not be sued. It's a precarious path.
Yep.
But, developers and semi-indie developers, if they have a vision for a game, they want to produce it. And what if they got a bunch of money, don't retain the IP, the thing doesn't get green-lighted, and they want to go ahead anyways? That's the lawsuit that I keep seeing almost happen.
Mm-hmm. There's a lot that almost happens.
Exactly.
That doesn't.
Yeah.
And there's things that are about to happen.
Yes.
I can't talk about that one, but stay tuned.
Yeah.
Watch next week. There's a new one in town. Okay, this was the Zynga versus Vostu case. You guys familiar with this one? This was written up a lot. It was splashed all over.
Yeah, this wasn't long
TechCrunch.
ago. This was a year and a half ago, maybe.
Yeah. So Vostu, which was described as the Brazilian Zynga, look, I'll be frank, it cloned 5 of Zynga's games. This is Vostu. I mean, look at the similarities. If that's not substantial similarity, I don't know what is. Zynga had even alleged that Vostu had copied the game so closely that they copied some errors in the game by which some roads didn't actually connect in the way that they were supposed to. That is not a good fact for a defendant. So this was one example. There were 4 others that they had copied. And this one, Vostu filed a very aggressive counterclaim. And actually the partner that worked on that case joined my firm during the pendency of this case. I didn't work on it, but he did. And basically the theme of their defense was, you don't own what you claim I stole. Zynga, you're a notorious copier. And, you copied your, what is Zynga's? Farmville, right? Farmville is a ripoff of Farmtown. And their complaint, or their counter complaint, listed in great detail with screenshots all of the things that Zynga is alleged to have stolen from other people. And it's an effective defense, and it was splashed all over the news. And The case settled shortly thereafter, and while settlements are for the most part the terms are always confidential, it was reported that Vostu made a payment and agreed to change 4 of their games.
So when you say it's an effective defense, do you get a legal defense, or it just doesn't look good? Is it just hot?
No, it's an effective legal defense because it's challenging the ownership of the copyright. You can't own that because you didn't create it. Yeah, and I say it's very effective also because that is a lot of what's happening. There's little that's truly original in every respect. You can always find aspects of games that aren't original, and there's a lot of them, particularly that Zynga has done, that really you can look back and identify games that came before it that look very, very similar.
I'm curious, if I make the defense, I did copy from Bob, but Bob doesn't own the copyright because Bob copied from Alice. Did I just set myself up for the easiest lawsuit ever by Alice?
Because Bob copied Alice and then you also copied Alice?
Well, no, I say, okay,
Yeah.
fine, I copied Bob, but Bob doesn't own the copyright because Bob copied Alice. Did I just walk into a lawsuit from Alice to me?
Maybe.
Okay.
Maybe. I have not seen that happen, though. Not everybody wants to sue. And who knows what Alice's vulnerabilities are. She may have problems with her copyright. But I have a couple of clients that have, plenty of resources to fund a litigation. And in my view, probably should file a litigation in some circumstances, but they just don't want to do it, because, for business reasons. We don't want to be that guy. We don't want our users to be mad at us. We don't want that reputation. And so some publishers just don't want to litigate. That's just the reality of it.
But that's not what this is.
No.
Because when you're looking at, dead-on clones, it's very hard to stomach that.
Yes. Yes. And they were threatening. Vostu was threatening Zynga's business model, and so this was a must do for them. Okay. This was the Tetris versus IO Interactive case. Look at the similarity here. Pretty startling, huh? And I say this every time I give this talk. If you're going to copy somebody, please, for the love of God, do not copy Tetris, because they will sue you. They fiercely protect their IP, and they have sued a lot of companies. And in this case, the company that developed this game called Mino, which is short for Tetramino, which describes these shapes here, admitted that they had studiously copied the game Tetris. They built this game for the iOS platform. They said, yes, we did copy. We intentionally copied. But what we copied was not protectable under copyright. All that we copied were the functional aspects of the games and things that were required by the rules of Tetris. And the court rejected that, and I think rightly, because there are so many visual similarities here in terms of just the appearance of the blocks and the shapes. That wasn't necessary. There's many different ways in which you could have built a Tetris-like game, and they just didn't do it here.
If you did it with triangles, do you think it would be enough?
It would be a terrible game.
Tetris with triangles.
Yeah. No. I don't think that would be enough. I think, no. I think more is required. Now, I could make arguments that maybe. I would try to make arguments that having a 10 by 20 was a functional aspect of the game, and that was not protectable. In this case, the court found that the game's dimensions were within the scope of copyright. In the Spryfox case that I think is next in line, or maybe one after it, the court said the use of a 6 by 6 grid that could be driven by functional considerations, so I'm not gonna put that on the expression side of the line. But here, what the court found was protectable. And this was a summary judgment case, by the way. Cases almost never get to this point in video game cases. Almost never make it this far. And I can't think of any that have gone to trial.
So you know, I saw one game, actually, a student from the Center for Digital Media made a game, which was this in reverse. it was a shooter where you were shooting the Tetris piece and things that looked like the Tetris pieces moving down.
Mm-hmm.
Never got sued because it was actually a different genre of game.
Uh-huh. Well, and back to the point that I made earlier about games that are fanciful getting more protection than games that are based on real life. I've written an article on this where I said, I think one of the things that was driving this, and the court actually says this in its opinion, this game doesn't have a real life counterpart. Tetris doesn't exist in the real world. It's fanciful. And you didn't need to there's nothing about this that is necessary. So what the court found in this case, what was protected by copyright, was the design, movement, remember that word movement that we talked about earlier? Color, shape, and shading of the game pieces, the game's dimensions being 20 units by 10 units, the previewing of the next piece to fall, ghost pieces which allowed a player to see where the piece will fit if it is not moved, and garbage lines, which was a random row of blocks placed on the board by the game. So in this case, the court granted summary judgment in favor of Tetris, and there is a written opinion on that I encourage you to take a look at in all of your non-existent free time. I think I might have missed one. No. Okay. So this one, this was Spry Fox versus Six Waves. And this one came out a couple of days before my talk that you were at, John. And I read the opinion as I was getting on the plane, and I got to the lecture, and while I was waiting to go on, I downloaded the games onto my iPad and played them in the background, and I was commenting to my neighbors, my God, wow, look at this. They totally ripped them off. So what happened here was the plaintiff was Spry Fox, and it had this game, Triple Town. And it was available, I believe, on the Kindle. And they entered into talks with LOL Apps, which was merged with Spry Fox just before the litigation was filed. So I'm just going to refer to them as Spry Fox, even though the title of the case is I'm going to refer to them as Six Waves, even though the title of the case is Spry Fox versus LOL Apps. They entered into negotiations with them and actually and signed a non-disclosure agreement. Six Waves was going to develop a Facebook version of the game for them, and that fell through. And then they were talking about developing an iOS version of Triple Town for them, and that fell through. And all of a sudden, Spry Fox gets an email from a guy at Six Waves who says, so sorry, but we're backing out. We're not going to do this for you, and you're not going to like it, but we're coming out with a match 3 game that's very similar to yours. Sorry, don't hate us. And Spry Fox did just that, and it sued them. And Six Waves filed a motion to dismiss and lost. And what happened there was the court said, no, there's enough here to state a claim for copyright. It didn't decide on the merits, because this was just a motion to dismiss that was denied. But what it said was these are basically the same game. And it used the term object hierarchy to describe the way that the player progressed through the game, in terms of the player moves objects around and groups 3 objects together, which then become a new object. And then those 3 objects can be grouped together to become a different object. And all the while, your progress is being disrupted by an antagonist in the game. In Triple Town, it was a bear, and in Yeti Town, it was this silly-looking Yeti over there.
But isn't that a genre of game?
Match 3, that's a genre. Yes, absolutely.
And therefore not protectable.
Well, yes.
But the court didn't go that way.
No,
so why not?
The court did not go that way. I think the court was blown away by the similarity of the games, and I think also influenced by the fact that the parties had a relationship. Six Waves clearly had access to the game. It made a game that was identical. And while these screenshots don't reflect all of the similarities, the complaint does, and it has things like a tutorial. You know, if you move the bear in a certain way, it turns into this. If you move the Yeti in a certain way, it turns into this. And the tutorials look the same. Now, looking at this visually, I don't think the visual presentation is the same.
No.
They look very different. It's the same concept. It's the same game, but it looks different. Plays the same, but is that protectable under copyright? And the court did note, I'm not going to find that the grid, the 6x6, could be protectable because that could be functional. But what it said was about, what was interesting is the court said, yeah, I recognize that the games have things that are not similar, but that's not enough to get you out of liability. It says, put another way, a writer who appropriates the plot of Gone with the Wind cannot avoid copyright infringement by naming its male protagonist Brett Cutler and making him an Alaskan gold miner instead of a Southern gentleman. The differences between Tripletown and Yettitown are more meaningful, but it is at least plausible that they are insufficient to overcome the similarities. So the case settled very shortly after the motion to dismiss ruling. And while the terms were confidential, SpryFox did announce that Six Waves had transferred all of the IP in the game to SpryFox. Okay.
You got like
Yeah,
7
I'm gonna
minutes.
skip this one. This is, you know,
Just a bunch of people who were just really, really angry at each other.
yeah,
And
EA was furious.
Yeah.
EA was furious. Zynga was hiring its people, and they came out with this game. You know, the EA has, The Sims goes way, way, way back, and they had made a version for social called The Sims Social for Facebook. And then Zynga came out with The Sims, or with the Ville.
This was the kind of internecine warfare that happens when people don't like each other, and it's less about the game than
Yes.
about the internal politics
Yes.
of the industry.
Yes.
And it went away.
Yes, it did go away. And in fact, what was interesting about this is neither one of these games did well on the platform. And I think both companies sunsetted the games shortly after the lawsuit was filed. So it's like, what are they fighting over?
Yeah. And from a legal perspective, I mean, for this is a law course, there's nothing here. Move along.
Yeah, yeah. One thing I do want to say about this is an image from the complaint. And this looks very similar, doesn't it? I mean, yeah. But what is this image, okay? This image, this is a home that was customized by the player. The player chose to paint the walls purple. The player chose to move the refrigerator here and to dress her in a striped shirt with the knee-high boots and the shorts. This is all customization by a creative lawyer who wants to come up with an image that looks exactly the same.
So the lawyer can make this. Of
Yes.
course you can. So in other cases, which you'll read about in the textbook, you can't. Marvel sues because in another game you could make, using the tools, the Incredible Hulk, which you could.
Yes.
But you have to make it to infringe,
Yes.
and you don't have to make the Incredible Hulk.
Yeah.
So it's that issue, and I'd say read the text.
And here's what I think is going to happen at some point. You're going to be able to customize somebody that looks a lot like a famous person, and that famous person is going to sue.
Exactly.
Then what? Did the developers deliberately give them the tools to be able to create the character? Should that give rise to liability?
And so you have to go back and think about tools. Do tools, you have to go back to Sony and Universal, which we've talked about and we'll talk about again.
So the next two screens are both from a case that I just litigated. Pet Rescue Saga and Farm Hero Saga are published by King, which I represent. And the defendant in that case was Six Waves. And what did we say about Six Waves in our complaint? We made hay out of their prior bad acts, and but we didn't even have to because the images were pretty unfavorable for them. I mean, look at this. You know, why the same color choices? And this is just a tip of the iceberg in terms of the images that we put in the complaint. Six Waves, we filed a suit against them in August 2013, and they mounted a very aggressive defense. They tried to get the case dismissed under the doctrine of forum nonconvenience, which means this is not a convenient forum for us. They said, we developed our subsidiary in Beijing, which was not a party to the case, developed the game. And everybody that knows anything about the game is in Beijing. And we don't have any connection to the US. And we said, you're distributing solely through Facebook, which is here. We think you're using servers located in the US, which we didn't know for a fact, but it turned out to be true. Your CEO lives in this jurisdiction, and we in fact served the complaint on him at his house. And you're not even distributing the game in Facebook or in China, which blocks access to Facebook. So yeah, you're here. So they lost that motion, and we went through some discovery, and eventually we settled, and we were able to disclose in our settlement that we got a stipulated injunction. The games came down; they're never going back up, and that they had to pay a bunch of money to King. That's pretty unusual in a settlement. You normally don't get to say anything like that, but it was important to King to be able to say that. And I would be surprised if we saw Six Waves cloning anybody anytime soon. I think they've learned their lesson.
A lot of what it is the inherent similarities exist in the game itself. But what if they released a patch or an alternate skin, like they did in the Sim sort of game, that allowed you to, if you wanted to, you could make this game look a lot like another game.
Yeah.
Or downloadable content that allows you to turn this into. Would that still?
So if they release a patch that they start out similar and then they become more different.
Oh, no, if they start out different and then they release something that's
And they release tools that allow the gamer to make something that's similar.
Yeah. Well, again, fodder for lawyers to argue. This isn't something that the developer did. These are choices that are made by the user. And so it's not something that that the developer should be on the hook for.
Yeah, I'm pretty bullish myself, as you would expect, that mere tools do not create an infringement.
It's pretty easy also to change a game. And I warn clients about this when we're looking at something that a clone has done. And clients often say, well, gee, I don't want to file a lawsuit. Can we just get them to change the game? Can we send them a demand letter? And I say, you're running a big risk that they file a declaratory judgment action in a place that you don't want to be. And a lot of these developers are not in the U.S. Or you run the risk that they'll just make unilateral changes to the game and take gut your case. And in fact, I've had clients who have gotten letters and I've said, just change the game. What are they going to do now? They're going to sue you for past damages? Doesn't make economic sense. If you do it early, the amount of damages are just not worth pursuing in court. The most powerful thing that you can get is an injunction. In fact, the possibility of an injunction is absolutely terrifying to a publisher because it cuts off your revenue stream. And if your distributor, like Apple or Google, thinks, gee, you've gone too far, it can yank the game before there's even been a determination by the court. So I've only got a couple of minutes left. I think rather than spend time on this slide, which you can just sort of take a quick look at, this is sort of the analysis that I go through when I am analyzing whether games are
You've
similar.
really gone through this, in fact,
Yes.
in the course of this lecture. So the slides will be up,
Yes.
as they always are.
Yes, yes. So any questions from anybody that didn't get raised along the way? Have I motivated anybody to want to be a litigator that didn't already think so? It's really fun. It's a lot like chess. Yes.
Do you ever get to bill clients for, playing games for research?
Yes. Yes. I actually had. This is true. This is true. I had a conversation last week with a new first year at my firm. He literally just started, and he said, "I really want to talk to you because I very much want to do what you're doing, and I want to know how you got into it, and I want to know how can I do it too." And
This is the perfect ending. So
yeah.
tell us.
And I said to him, "Look, I am going. If you want to do this, great. You're the first person I'm going to call." And I don't want you to chuckle when I say you're going to have to play the games. You absolutely have to play the games. I don't have time to play the games. I need you to play the games. And you can eat popcorn, you can eat whatever, have fun with it. But I need you to really play them deeply and to deeply understand them and then tell me where the line is. So, yeah, but when we had the Capcom case, we all sat down in a conference room and we watched Dawn of the Dead. And we also watched Night of the Living Dead, which was the work that came before it. And actually the copyright had fallen into the public domain. And so we made arguments. That is back to that point of, are you copying from Bob or Alice? We said, we didn't copy from Dawn of the Dead. If there was any copying, it came from Night of the Living Dead, which you don't own and can't protect anyway.
So there's one snippet of a conversation we had this morning, and it sort of bears on this. and that is we talk to each other about the fact that we look longingly often at our game consoles, wanting to play. So the fine point here is the reason you love this stuff is because you love it and you want to play. When you're in it or when you're teaching about it, you don't have enough time. But as long as your passion for it is real, and what makes Jennifer and what I think makes people successful in this area, it's my view, is that if you love games, you will be successful because the underlying passion and understanding will be there. There are lots of lawyers in this area who might gloss over the fact that they don't really play. But they're interested in the fact that it's become one of the biggest real businesses around, and we're kind of chilly to that. And we kind of recognize who really plays games.
Yep.
Jazz plays games.
Yes, he does.
So that, it is, it's not an insiders club, but the desire to play games as part of what you're doing in life or what you're teaching about in life will make you better at it. I'll leave it at that.
Yep.
So let's thank Jennifer and her firm for sending her up. And it's really a big deal, and I think you have a good sense of what a privilege it is to have her here. So thanks.
Thank you.